Must trial courts in Utah consider the consequences of their orders and judgments in divorce actions? Generally, it appears that the law in Utah is that the trial court is not required to consider hypothetical and/or future tax consequences of the disposition of the marital estate. See Howell v. Howell, Volume 806, Pacific Second Reporter, page 1209, Utah Court of Appeals, 1991. There is no abuse of discretion if a court refuses to speculate about hypothetical future tax consequences of a property division made pursuant to a divorce. See Alexander v. Alexander, Volume 732, Pacific Reporter 2nd, page 221, Utah Supreme Court, 1987. Tax consequences in that case were speculative as to whether they could be avoided or delayed, and as to amount. The court heard testimony and evidence regarding possible tax implications, but did not err in refusing to adjust property distribution because of those theoretical consequences. And see Rothwell v. Rothwell in paragraph 53, Utah Court of Appeals, 2023. Quote, "The district court's decision not to tax affect the business is consistent with Utah law." Quote, "We do not generally expect courts to speculate about hypothetical future tax consequences." Close quote. See Wadsworth v. Wadsworth. That's a 2022 Utah Court of Appeals case. Rejecting the argument that a wife's property award should be decreased based on possible transaction costs the husband would incur if he liquidated the business. See also Morgan v. Morgan, 795 Pacific Reporter 2nd, 684. Utah Court of Appeals, 1990, explaining that courts are under, quote, "no obligation to speculate about hypothetical future tax consequences," close quote. The sale of a business has tax consequences only if the business is actually sold, which may be long in the future when tax laws have changed, or may not happen at all. You can also compare these cases to Howell v. Howell, Volume 806, Pacific 2nd, page 1209, Utah Court of Appeals, 1991, rejecting an argument that the tax associated with selling real property should have been deducted from the value of the property because such taxes were speculative. And yet there is this distinction from the case of Laban v. Laban, Volume 517, Pacific 3rd Reporter, page 407, Utah Court of Appeals, 2022, where the court found, "A court should consider the tax consequences associated with the division of marital property if one of the parties will be required to liquidate assets to pay marital debts." They also quoted Morgan v. Morgan in that case, 795 Pacific 2nd, page 684. Even so, if the tax implications of the division and disposition of the marital estate are important, they should be made specific trial issues, and the parties should expressly ask that the court consider and should minimize adverse tax consequences incidental to the disposition of the marital estate. Many treatises and practice guides recommend that every argument at the motion and trial level address the tax implications of the argument in detail, backed by not only the documentary evidence, but the expert explanations, analyses, and opinions of an accountant.